Please be seated. The seating is resumed. I will now give the floor to Professor Philippe Sands. You have the floor.
Madam President, members of the court, it is an honor to appear before you on behalf of Somalia. You've heard from Professor Pele on the legal aspects of Kenya's arguments on acquiescence and related claims. My task is to address the evidence that relates to Kenya's case on acquiescence, on the acts of the parties. Notwithstanding the evidence on the record, Kenya asserts that for more than 3 decades between 1979 and 2014, it expressly, publicly, and consistently claimed a maritime boundary along the parallel of latitude, that this claim was precise and unequivocal, and that Somalia never protested against it. Each of these assertions is wrong as a matter of fact, as the evidence on the record makes clear. Kenya's case on acquiescence is actually constructed on a series of rather obvious factual contradictions. Kenya alleges that the parties have already delimited their maritime boundary along a parallel of latitude. Yet it has repeatedly adopted positions and made numerous formal public statements, including its own written and oral submissions before this court, in this court's jurisdictional phase, that reject the existence of any delimited maritime boundary and that explicitly stress the need for delimitation to take place in the future. Moreover, Kenya has also repeatedly acted in a manner that is consistent with an equidistance line and inconsistent with the parallel line that it now claims Somalia has somehow acquiesced in. Kenya's contradictory statements and acts are too numerous to list in a single speech. They are fully set out in our written pleadings. However, a brief review is sufficient to establish the absence of evidence to support Kenya's acquiescence argument, a point that will be apparent to those of you who, as judges, sat in this great hall of justice and listened to Kenya's preliminary objections 4.5 years ago. An objective appraisal of the evidence shows that Kenya's case on acquiescence is simply an attempt to rewrite history and the facts. Kenya seeks to avoid the application of the standard 3-stage process for maritime delimitation, starting with the construction of a provisional equidistance line. The evidence makes clear that Kenya's case on acquiescence is hopeless. It is contradicted by its legal submissions, by international and domestic instruments, and by public pronouncements. It is unsupported by any evidence on effectivité in the disputed maritime area. It is contradicted by Somalia's conduct, which offers no support whatsoever for the acquiescence argument. So let's begin with a point on which there is, happily, common ground between the parties, and it's a point that's already been considered by the court. There's no dispute that in 2009, Kenya and Somalia did enter into a Memorandum of Understanding, the MOU, nor is there a dispute about the terms of that MOU or its legal status. As Kenya stated during the preliminary objection stage, and I quote, "The MOU's terms are plain and unambiguous. Its legally binding nature is equally straightforward," end of quote. And then to take the words of this court, the MOU is, and I quote, "a valid treaty that is binding on the parties under international law." End of quote. Accordingly, there can be no doubt that insofar as the terms of the MOU address the delimitation of the parties' maritime boundary, they bind the parties as a matter of international law. Does that valid and binding treaty, the MOU, support Kenya's claim that the maritime boundary has already been delimited by virtue of Somalia's acquiescence in a consistent and long-standing claim by Kenya? It does not. To the contrary, the MOU expressly records that, and I quote, the delimitation of the continental shelf between the Republic of Kenya and the Somali Republic has not yet been settled. This unresolved delimitation issue between the two coastal states is to be considered as a maritime dispute. These words, agreed by the parties in 2009, could not be clearer. They are of themselves sufficient to end Kenya's acquiescence argument. The MOU also refers to the delineation of the continental shelf beyond 200 miles without prejudice to the future delimitation of the continental shelf between them. The MOU states, the delimitation of maritime boundaries in the areas under dispute, including the delimitation of the continental shelf beyond 200 nautical miles, shall be agreed between the two coastal states on the basis of international law after the Commission has concluded its examination of the separate submissions made by each of the two coastal states and made its recommendations. The terms of the MOU are clear and unambiguous. How does Kenya seek to get around their plain meaning? Well, it argues in its rejoinder that in 2009, only delimitation of the continental shelf beyond 200 miles was at issue. This was, if I may suggest, an audacious assertion, given that it was made only after the court had already held that the provisions regarding delimitation in the MOU were concerned with the area of the continental shelf both within and beyond 200 nautical miles. That's the court's words. Your ruling, this court's ruling, is res judicata. Kenya seems to be asking you to reopen the matter, in effect to rule that you got it wrong, or that you are now entitled to rule differently. With respect, Kenya cannot avoid the conclusion of the court that it is bound by a treaty which expressly acknowledges that as at 2009, the parties had not delimited their maritime boundary, not within 200 miles, not beyond 200 miles. Kenya's case on acquiescence invites the court to ignore the unambiguous words of a binding international treaty and its own judgment on jurisdiction, and to replace them with their opposites. For Kenya, the words "has not yet been settled" are to be interpreted as meaning "has been settled." For Kenya, the phrase "unresolved delimitation issue" seems to mean a fully resolved delimitation issue. For Kenya, the words "shall be agreed after" in fact mean "has been agreed before." And for Kenya, the words "future delimitation" actually means past delimitation. This makes the world of Alice look reasonable, a through-the-looking-glass kind of approach to treaty interpretation, in which language is turned on its head, the facts are inverted, and there is no law. The contradiction at the heart of Kenya's case is thrown into even sharper relief by the conflicting statements that it has already made to this court. In its rejoinder, Kenya argues that the parties delimited their boundary by acquiescence long before Somalia lodged its claim before the court in 2014. Let's go back to 5 years ago, during the preliminary objections phase in 2015 and 2016. Then Kenya repeatedly told the court that the parties had expressly agreed that their maritime boundary would be delimited in future by a process of negotiation. Let's look at what Kenya stated in its written preliminary objections. Here's what they wrote then. The parties expressly agreed on a negotiated settlement of their maritime boundary. This was consistent with Kenya's legislation requiring delimitation by agreement with Somalia. It was also consistent with the provisions of UNCLOS. Indeed, Kenya alleged that by filing its application with the court, Somalia had, to use its words, attempted to circumvent its obligation to negotiate an agreement on delimitation after CLCS review.